say we kept the guns out of the hands of 2 million people. They were not all that dangerous because, again, you only prosecute 6. But I want to move on because I do want to delve into marijuana a little bit.
Were a host of people who, if they had gotten guns, undoubtedly would have done things that were harmful to their fellow citizens.
But not bad enough to prosecute. So let me just move on because I want the medical marijuana. To me, look, I'm a physician, and as I tell people, there's only one federal license I've held for 30 years, my DEA license, because the federal government is deemed under the Controlled Substance Act that is so important to control that for the health of people in the United States that we're actually going to create the DEA and we're going to enforce those laws. So we had the administrator in, and you heard the questioning earlier. The administrator was pretty clear that there's evidence that drugs are dangerous, that especially for children, they lead to actually permanent changes in IQ. They learn permanent change in health, potentially augmenting mental illness, clearly increase accidents and injuries. They're dangerous. And you did indicate that the president did not say that he was for legalizing marijuana. But more importantly, the president didn't say he was against it. So here you have the DEA under schedule with a Schedule I drug, no medical use, clearly illegal, and the president not taking a position against what happened in Washington and happened in Colorado. And my specific question is that because of the supremacy clause of the Constitution and the ability to preempt, it's pretty clear from some of the case law that you couldn't overturn local laws and state laws under medical marijuana. But we've crossed a threshold now. Washington and Colorado crossed a threshold that actually that appears perhaps pretty clear in a couple of the cases and a couple of the rulings, that there is a possibility to go in if we felt, and the Justice Department agreed, that marijuana is dangerous and that it deserves its Schedule I classification, that your department could choose to overturn those laws under the obstacle element of the conflict preemption. They could choose to attempt to overturn laws and send a clear message to the states, we're going to draw the line at medical marijuana. And maybe there are some cases where we're just not going to go there, but we are going to send a clear message to America's youth that marijuana is not a safe drug. It is illegal, and it's going to be dealt with under the Controlled Substance Act, and we are going to send that national message. Is that possible? Is that among the realm of possibilities under consideration that the Justice Department could draw that line and send that clear message, or are we going to have the message a fairly obscure? I guess a message is just not a clear message to American kids. I mean, you say well, I don't know if it's bad. I don't know if I'm against it. That's not a clear message. I mean, look, I have 5 kids. I got you plus the president. Add them all together. I got as many as you combined. Kids need clear messages, and I'm afraid we're not sending them one. Would that send a clear message? That's something that you consider. Taking the 2 states to court and saying we're going to ask for a ruling in a federal court on whether we preempt state law.
Well, as indicated, that is something that we have under review, and there are a number of factors that I went through before that we have to consider in making that determination.
And what factor, could you be a little more specific with it? Because, we have, CRS has looked at this in at least 2 reports, and it's been 6 months since November has occurred. These programs are gearing up in those 2 states. I mean, do you agree with me that an argument could be made for preemption, again, for conflict preemption under the obstacle element, that a line was crossed, and this is now, those states are clearly in contradistinction to what the intention of the CSA? Could that case be made?
The case could be made with regard, I think, to at least part of the statutes in that regard. And these are the things that we have to take into consideration. What kind of case could we bring? The strength of that case. Would our ability to try to preempt apply to the totality of those statutes? Those are all the kinds of things that have to go into the determination that we will ultimately make.
And who is going to make that determination?
I will be making that determination, I believe.
And the time frame of that?
We will do it.
Because children are dying from drugs. It is a scourge. And as the administrator made clear, marijuana is a gateway drug. Its use in teenagers is dangerous, and we are sending a very mixed message. So can you give me an idea? And I'm not going to rehash the timeline argument that went on before. Can you give me a general idea of when that decision is going to be made?
Well, let me first say this. When it comes to protecting children and making sure that children don't die, when it comes to drug use or anything else, I'm really proud of what this Department of Justice has done over the last 4.5 years. We have put front and center the welfare of our children. It has been something that I've been personally committed to. And so the decision that we make will be consistent with the policies that we have put in place with regard to the welfare of our children. There will be no tension in that regard. I'm confident of that.
I didn't hear the answer to my question is what's the time frame for that decision? About what will be done about the federal preemption question over Washington and Colorado's actions that are in pretty clear contradiction to the CSA.
And we're going to do that, make that decision as quickly as we can.
Can you be any more specific than that?
No.
Fall, winter?
No.
No. Do you imply, since the answer is no to that, then I'm just going to ask Mr. Chairman just for another minute, because then I have to ask, what are your plans to enforce the laws in those states while you're deciding whether or not to actually go to court and strike down the law under federal preemption? What is your action to enforce? I'm sorry, the laws in those states, the CSA in those states.
Our enforcement efforts remain the same as they always have been. There are policy guidance that we have given the U.S. attorneys from, I guess, 2 deputy attorneys general who served under me with regard to how we use Justice Department resources.
You know, Mr. Attorney General, you're referring to the Ogden and Cole memorandums.
Yes.
You know they referred to medical marijuana. You are aware of that.
They refer to.
I'm not talking about medical marijuana. I'm talking about the.
Can you let the gentleman answer
They
your
refer
question,
to medical marijuana, but you can glean from those memoranda what the Justice Department policy is with regard to how resources ought to be used in this field. There are things that are more generic that go beyond the parameters of the medical marijuana guidance. You can glean from those memos. If you read them, it's pretty clear.
And what about the officials who now, under the question of authorizing activity instead of approving activity, if those statutes are found to obtain authorization, I mean, do you intend to pursue action against the officials who authorize it? Because that was not covered in those memoranda.
These are determinations. Again, we're looking at we're looking at a new set of initiatives, statutes that have been passed by these 2 states, and those determinations have yet to be made by us. And we will do that, as I said, as quickly as we can.
Okay, thank you very much, Mr. Chairman.